Please be seated. We are here today, welcome, in our case number CV16-0617, Dorosti v. Recovery Innovations. Counsel, each side has 20 minutes for argument. The appellant may reserve time if you want. I would just ask that you keep track of it yourself. The proceedings are being recorded, both audio and video, so if you would introduce yourself when you come up to the podium, I would appreciate it, and your client. We've read the briefs and discussed the issues, and with that, we're ready.
Good morning, and may it please the court. My name is Chris Knatzer, and I represent the appellants, Recovery Innovations of Arizona. Your Honors, I'm going to get straight to it. I'm going to try to reserve about 5 minutes for rebuttal. The trial court abused its discretion in limiting the new trial because it foreclosed reconsideration of the issue of liability, because it separated the inseparable issues of comparative fault and liability, and because it did not resolve the risk that there might be prejudice in favor of a new trial on liability. On the first point, the limited new trial violates Recovery Innovations' right to have its liability reconsidered by a jury exhaustively deciding all of the issues. That right was recognized by the Supreme Court of Arizona in Perkins v. Karmanitsky.
Counsel, let's talk about Perkins.
Absolutely.
Is that text that you describe as the standard ever been followed after Perkins?
Not that I'm aware of. It's consistent with Rule 59E, and when we're looking at the separability of the issues, it's right on point. I think that the issue in Perkins about whether a full jury has decided all of the issues and might reconsider liability is going to apply to any case like this where you cut out an entire issue.
Perkins was quite different, though, wasn't it, in what happened and what should have happened?
Not if you look at the precise holding on and what the case turned on. There was
holding was that all the jurors, regardless of how they determined liability, needed to deliberate for damages. Is that fair?
That's correct.
And the error there was a trial judge instructed the jury, setting aside the ex parte nature of that only the jurors that found in favor of liability should deliberate. Fair?
Correct.
So you had a subset of the jurors identifying what a superset had considered on a different issue.
Correct.
And I don't see this case presenting that issue.
So here's the thing with Perkins. There was certainly an issue with the instruction, and we'll just set that aside. And you can look at it and say, yes, we have an issue with not all of the jury deliberating on the issue of damages. That's what this court had originally done, and it remanded for a new trial limited to damages. The very crux of the Perkins opinion, once it was up to the Supreme Court, was this second concept of how can we tell whether the jury unalterably decided that the defendant was liable when it could have reconsidered liability had a full jury decided all of the issues. And that's our case. In Perkins, it was just 2 jurors that were excluded on the issue of damages. In this case, it's uncontested that the trial court erred in failing to submit the entire issues of comparative fault and Mr. Najafian's negligence.
Well, in Perkins, did you have that same issue where you had separate issues that you had, I guess, that were separated, and the question was whether the same jury had to reach both issues, or again, was it that a full jury has to reach 2 questions that are before the court in that case?
So there's a separate issue of whether these can be separated, and I do want to address that. But as to Perkins specifically, the first jury in Perkins fully deliberated. The entire jury deliberated on the issue of liability, and they decided liability in favor of the plaintiffs. This court sustained that verdict on liability. The only issue in Perkins was what is the consequence of excluding just 2 jurors on the issue of damages. And the Supreme Court of Arizona recognized that the consequence of that was that through the course of allocating fault or in fixing damages, that the jury might reconsider the other issue for which the full jury deliberated on.
So let me take you back to the first sentence. You said there is a question whether issues need to be separated. Was that you started it that way? Isn't that the threshold question?
If they, under Rule 59E, that is the question. Are they separable?
Okay, so even it sounds like before you would get to your Perkins argument, you'd have to establish that these are two issues that need to be tried together, and then you pivot to Perkins and say, based upon that established point, a full jury had to address both. Is that your argument?
That's part of it. Because the Perkins court recognized that when the jury is allocating fault, it might reconsider liability, that inextricably intertwines the question of comparative fault with liability. But the other part is the right that the Perkins court recognized. It recognized that a defendant has the right to have the full jury, yes, the full jury, exhaustively decide all of the issues. If we look at it just from a numbers game of which jurors participated on damages.
Well, what does that mean, all of the issues? I mean, the rules of civil procedure provide for a partial trial in certain circumstances. If that's the rule, it would seem there'd be a per se rule against a partial trial where we would consider all of the issues as something larger.
Correct. And again, the point in the Perkins case is that these issues become inseparable, and that's the standard. If there's any doubt that there might be prejudice if we try these issues in separate trials, it's an abuse of discretion to separate them. In Perkins, we know because the jury might reconsider liability in allocating fault, that intertwines the issue of comparative fault and liability. But Perkins also recognized the right to have the full jury deliberate on all the issues, not because it's this issue versus that issue, but because the jury might reconsider the issue of liability when it considers the whole case and all the issues.
Under your reading of Perkins, could there ever be a new trial just addressing comparative fault?
So this court in Ogden and Progeny has told us that there can be.
Okay.
And I don't think Perkins can be read so expansive as to say that there can never be a new trial because liability might be the issue in the case. If there's a problem with an instruction on a particular issue and that doesn't evade and infect another issue, which is the same standard under Rule 59, we don't have an issue. But if we go to Ogden, the Ogden court and Progeny tells us the rule of when you can limit a case to the issue of apportionment of fault. That's when apportionment of fault was submitted in the first trial, and then on appeal, looking at that apportionment of fault, the court determines that the apportionment of fault was not justified by the evidence. But only when the error is in the apportionment of fault and the first trial was otherwise error-free. That's not our case.
Are there cases, though, after Perkins that come to that conclusion that don't involve the issues that you just described, that stand for a proposition that it has to be, it is error, it is abuse of discretion, unless those facts are shown to have a partial new trial?
Not that I'm aware of after the time of Perkins. What I can say is we've cited cases from jurisdictions outside of highest courts in jurisdictions outside of Arizona that have looked exactly at the issue of whether a defendant's liability and comparative fault can be separated. And I can go through those, but the point is they're inextricably intertwined when a jury has to go on to do comparative fault. We know that part from the Hassan opinion under a comparative fault statute that Arizona courts recognize as being analogous to Arizona's comparative fault statute. Perkins tells us that when the jury goes to apportion fault, they might reconsider liability altogether, and that's the right. That's the second part of Perkins, that a defendant has that right to have the jury reconsider their liability.
But could I just ask you,
Sure.
It's more a question of prejudice. Can't this second jury essentially do that in assessing comparative fault if they are told that a previous jury has found that recovery did something wrong, but they're going to be told that they don't have to come up with any number. They could be at 0.01%, or I'm struggling with how your client is prejudiced if the new jury assesses everything, and they have to assess presumably the exact same evidence that the first jury heard and the evidence of comparative fault. How is your client prejudiced? Is it just that the jury has been told that there has been a finding that recovery did something wrong?
So that's part of it. And so the standard is any doubt that there might be prejudice has to be resolved in favor of a new trial on all issues, and to fail to do so is an abuse of discretion. So that's where we're standing. The first part is Perkins. Under Perkins, liabilities or prejudice is conclusively established if we can't say that the first jury or the second jury wouldn't reconsider liability when it goes into apportioning fault. If we limit this new trial and say, okay, this defendant's liable, you have to apportion 0 to 99%, they're never going to, Recovery Innovations will never have a jury, while considering a portion of a fault, reconsider its liability, which is a right recognized in Perkins. But the other part of it is if we go back and we look at how this trial would have looked like but for the trial court's original uncontested error, the jury would have heard all the evidence. It would have considered the fault of all the parties at one time. It would have considered the timing of the fault, the circumstances of the fault, the duties and avoidance, the circumstances of the fault, and never would have heard an instruction that either party is already liable.
So is it accurate to say, do you intend to introduce any new or different evidence in the second trial? Possibly.
There was another issue, and this is brought up in our second motion for new trial. I can refer the court to it. There was a significant issue with the expert witness testimony, which is required to sustain the verdict under 12563.
But you haven't raised that.
We've raised that in our motion for new trial, which we've appealed here.
Did you argue it or raise it in the issues?
In the brief, no, and I don't think that it is.
Okay. So taking that and now looking back at that first trial, am I correct in saying the first moment in which error reared its ugly head was after the evidence was in, the jury had been instructed, and you were crafting a verdict form? Is that accurate?
That's accurate.
So the question really is whether one less line on that verdict form would have changed the whole result?
Well, under Perkins, we know that it's impossible to know if it would have. And when it's impossible to know, prejudice is conclusively established and liability has to be retried. But
Go ahead. I'm sorry.
No, please.
I did not mean to interrupt you.
Yeah.
Please continue.
So, but going back to if we look at what the first trial would have looked like and the jury would have considered all of this, they wouldn't have had an instruction that one of the parties is liable. How can the jury fairly look at Mr. Najafian's negligence when right out of the gate it's told that the defendant is liable? How can the jury fairly apportion fault with that instruction right out of the gate?
Is the question how can it fairly do that, or did the first jury fairly do that?
I think it's both. The first trial didn't fairly do it because it never reached the issue of apportionment of fault where they would have reconsidered liability in context. But
Well, you didn't have a comparative fault jury instruction. Is that accurate?
that is accurate. So
it's not as if that colored the narrative of the entire trial and you were presenting evidence through that lens. It's almost a two-step here, where you have an adjudication of liability, and then you have the verdict form, which asks you to break it down. What specifically makes, in this case, those issues inextricably intertwined and inconsistent, other than Perkins says so, generally? What is it here in this case, and I guess other than, the theoretical possibility that a jury provided with that additional line on the verdict form might go in the other direction? Can you provide us some insight on that?
Sure, and there's a couple issues there. Because we live in a comparative fault world, the jury has to assess the fault of all the parties and determine and apportion the relative degrees of fault as a whole at one time. I'm going to push back a little bit on the concept that liability has been judicially established. Set aside Perkins, I think we've talked about, I think that's addressed in the briefs. The Arizona courts have not treated liability as decided when there was an issue with the claimant's own fault. If we look at Tucson Industries versus Schwartz, where this court remanded for a new trial without limitation because the trial court erred in failing to submit contributory negligence, the exact same uncontested error in this case. If you look at Anderson versus Munoz, the court specifically refused to enter a judgment on liability because there was evidence of contributory negligence. When there was an issue with evidence of assumption of the risk in Ethan versus Rothburn, the court determined that the verdict on liability was inconclusive because there was an issue with the claimant's own fault.
If we look at liability as being liability for this percentage of damages, I mean, I'm struggling a little bit in terms of this prior verdict just says that recovery has done something wrong. Whether they have to pay something as a result of that is a different question. And it doesn't seem to me that it's going to be very difficult to argue, for your client to argue that the decedent did something wrong. He clearly did something wrong. So you're just starting with that both parties have arguably have done something wrong, but you as the jury have to decide who must pay damages. But why is it that prejudicial if we do have, and as you said, we went all the way through that trial, and this jury did find that recovery did something wrong. Whether that should translate to being liable for damages is another question.
Right, and I'm running short on time, so as quickly as I can. The issue there is, first of all, the second jury is not going to be told that Mr. Najafian's at fault. They have to determine that first, and then they apportion fault. So this is going to clout their determination on that. The second part is under comparative fault. They have to consider the fault of all the parties as a whole at one time, and then determine the fault of the parties and apportion the fault to meet the requirements under the Uniform Contribution Among Tortfeasors Act.
Let's jump on that. So the uniform contribution, are you pointing to I don't have it right in front of me, but the one that I guess is prefaced by relative degrees of fault. Oh, 122506.
C.
C. Okay, so that's what you say says you have to hit both liability and any comparative fault in one proceeding.
So under UCADA, the defendant is only liable for the percentage of fault, but look at the statute. It says determined and apportion. It would be
of relative degree, right?
Correct, but to apportion something and to determine something, if it's a relative issue, we're talking about two different things.
Determine and apportion modified relative.
Correct, to determine the relative fault of the parties and then apportion among the two. I'm going to, Your Honor, if I may say the rest of my time for rebuttal. Thank you.
I'm not used to being the appellee. I seem to have more garbage as an appellee than I do as an appellant. ARS Section 122506C is an important part of what's going on here, and it does talk about the relative degree of fault and the jury having the duty to determine and apportion that as a whole at one time, and that's what would happen on remand under what the trial court came up with. We're not talking about determining liability. Liability's already been determined. We had a full trial, 8-day trial, and the jury decided that Recovery Innovations was liable. Now we're just going to try to figure out, what is the percentage of fault, if any, that's going to be subscribed to the patient, to Mehdi Najafian.
What if the second jury comes back and they say there's no liability for recovery?
I don't think they can say there's no liability, but they can say we're not going to apportion any fault, and therefore your damages are going to be zero. I would be shocked if that happened.
So they would say you are liable because the first jury said you're liable.
Right.
But there's no pecuniary consequence or fault. How do those work together? That you can be liable, and I guess you're saying that the I guess here the decedent would be entirely at fault.
I suppose that a jury could do that, although I don't understand. Well, there's a side issue. Let me say, I suppose a jury could do that under the Constitution, Article 18, Section 5, and then under the statute itself, which really repeats the Constitution. It's 122505A, which is really just a reiteration of Article 18, Section 5.
So you're saying they would be consistent, the juries, if the second jury comes back
Right.
with the answer, you're liable because we have to find you're liable,
Sure.
but you are not at fault.
Yeah,
That's not inconsistent.
No, it's a consequence of the constitutional protections. You know, sometimes I applaud the Constitution heartily. I think it's a wonderful document. It's a product of a tremendous era in American law. But there's some creaking at the joint sometimes, and sometimes you get hoisted by your own petard. And in this case, if that happens, it happens. I don't see how it would. And my qualification as far as that, yes, was on a related subject that I don't think that's been fully addressed at the trial court, and maybe should be. When you talk about assessing percentages of fault against the patient who shows up mentally ill and disturbed in a terrible episode, and Recovery Innovations takes on that man as a patient, how do you get to blame the patient for being there? Your duty going forward is to treat the patient as well as you can, not kill the patient by piling people on top of him and asphyxiate him.
And how do we reach that issue?
I don't think you do, other than perhaps you could leave it open for the trial court. In your discussion, in your opinion or decision, I don't know if you need to discuss it a whole lot or even discuss it at all, but it should be looking forward something as a practical nuts and bolts matter for the trial court to deal with.
Why isn't that just your argument when the other side raises the comparative fault?
I think it would be a good argument, probably even a motion kind of argument at the trial court going forward, that you really can't do this. You can't say when you
You're
take
saying
on a
that patient
patient
can never contribute to to the harm that they ultimately suffer.
I think there could be circumstances. I cannot think of any, but in this particular case, I can't imagine what it would be. If you take somebody in who's had a heart attack, for instance, in an emergency room, and you botch the treatment, you don't get to say, well, you should have dieted better or should have exercised more. What's the matter with you? Or you take on somebody with lung cancer.
After he arrived at the facility,
Right.
he engaged in activity that we wouldn't expect the person with a heart attack to attack someone else. It seems very different than that sort of example. And wouldn't that all be fair game for them to bring up his actions in allegedly harming other people at the facility? Doesn't that all weigh into the juror's determination?
If you've taken on a mental patient having a severe episode, you've got to expect as part of your treatment protocol that he's going to be doing bad things, and you need to be prepared to deal with those bad things. And if you don't, it's malpractice, and if you kill him, it's a wrongful death.
But aren't we here on a more narrow issue?
Oh, far narrower.
On whether
yes.
the grant of a new trial for comparative fault
Right.
is an abuse of discretion. And you do at least hint that the argument that you're positing might be influenced by the constitutional right for the finder of fact.
It may be.
We're not asked to decide, and a trial judge may never be asked to decide as a matter of law, that comparative fault principles shouldn't apply in this context because of the nature of the relationship.
Right. The job here is simply, can you, now that you've had a trial where the damages have been set and liability's been determined, and the other side's not contesting the damages at all.
Let me ask about that. It seems conceptually, if this jury trial occurred as it should have, I think all parties concede, the jury would have been asked to do three things, I think, in this order. Is defendant liable? If so, how much damages did plaintiff suffer? And if that number's above zero, who is responsible in allocating fault for those damages? Would you agree kind of with those three steps?
Yes.
What I struggle with, and this is a question I want to ask the other side as well, is damages aren't challenged here. So
Right.
it's kind of the hole in the donut. The challenge by appellants, I think, is to say, well, we'll keep the damages in place, but we want a new trial on liability, which is sort of a precursor, I think, to damages, and then assessment of fault, which I think by definition would come after. Is there any case law talking about that?
I don't think so. And it's sort of like you've got a pie, and now you've got this pie. What we're going to determine in the kitchen is now how we cut the pie up. So at the new trial, how do we cut this $2 million pie up? So, you know, and I've been looking at this pretty hard, especially last night. I keep round and round. Well, they've admitted there's damages. How could they not say, well, we need to figure out how to cut up, how to divide the damages? It's an admission that there's liability. If you've got damages, somebody was liable. But now divide it up. You know.
Do you necessarily have to do it in that order? Can you switch 2 and 3? Can you say the defendant's liability, comparative liability, whatever it is, they were 50-50, and then now we're going to assess the overall damage. Does that matter? Is it necessarily, is the defendant liable? What are the total damages, and now what are the comparative? And does that matter?
Well, that's sort of why my yes to Chief Judge Stumble was sort of a yes instead of a nice hard yes. I think the right way is to, are you liable? What are the damages? How we divide that? But you can almost say, are you liable, and are other people liable? What are the damages? How you divide it?
But isn't that their point, that you need to that this is part of that assessment? So even though we've got an overall, we put a value. It's simpler in a workers' compensation case where you can look and say somebody lost a limb, and this is the amount we're going to say is the damage. But they're suggesting that this is more. This goes to this initial analysis of the defendant's liability, other parties, the defendant's fault, other parties' fault. We're going to compare that first before we get to the overall number.
Yeah, I don't know. I think my yes answer, I'd like to firm it up a little bit. It makes more sense to say, is anybody liable? Are you liable? And the defendant, are you liable? And if so, what are the damages? And then deal with trying to apportion it up.
Let me ask about that. I mean, in terms of liability, not comparative fault, but in terms of liability, it is, in this instance, it would be defendants, one defendant, both of them, or none, right? It would not. Plaintiff's not going to be liable, and non-parties aren't going to be liable. They may have fault attributed to them by the jury, but the liability call is only as to the defendant.
Well, we're getting some interesting conflation there from the other side. They're saying that Mehdi Najafian is really at fault. He's really liable for hurting himself.
Well, and I understand that, but in terms of those three questions, a jury's not going to find liability for a plaintiff. It may find fault for a plaintiff, but I'm sort of guessing no matter how the verdict form and instructions are structured, there's not going to be liability that plaintiff is liable to plaintiff. I mean,
I would hope not. It wouldn't make any logical sense to me. But then you get into another issue that's that's just been brooding off to the side. What is Mehdi Najafian's status in all this? They persist in calling him the plaintiff, and he's not. He is literally a non-party at fault. I mean, it may sound a little screwball to talk about a decedent being a non-party at fault.
The second trial, as I understand it, the second jury will hear all the same evidence that the first trial.
Yes,
Right.
And there was ample evidence about Najafian.
So is it fair to say your argument is premised exclusively on fairness and not on efficiencies in any way?
It's focused on, well, fairness, of course, but fairness in the sense that we've got a statutory and a procedural system for dealing with these kinds of problems. The jury gets to assess a fault, and under a non-party at fault system, they get to assess it against parties and against properly designated non-parties and come up with a number. In
a perfect world, one jury would have done both here, right? That's how it's normally done. Is that accurate?
Yes, sir.
Okay.
Absolutely.
So why can't we do that here? If we're going to go back and we're going to have the trial again, Why can't we pursue that preferred avenue?
Well, as long as it doesn't, our concern is we don't have to retry the entire case to reestablish liability, that you can start with the bedrock that this particular defendant is liable. And now the task of the jury is, your task is to determine the fault that should be attributed to Medina Jafian in all this. Assess a percentage of fault against him.
What's your response to the interpretation of Perkins that this jury, the first jury definitely found liability and that recovery did something wrong, but after considering comparative fault, they might have changed their mind on something? Why isn't that a reasonable reading of Perkins, that they could have, as part of the assessment, they could have rethought their initial conclusion?
Well, it doesn't make a lot of sense to me. The central question is Recovery Innovations liable or not? It's a yes or no. And they said yes. Now, what's the percentage of fault is a different but related question. Are you liable? Did you do something wrong? Something you shouldn't have done?
But they've made that determination in Perkins, and then just some of the jurors weren't allowed to deliberate regarding damages.
Yeah, but
so why did
Perkins? I think the trial judge in Perkins was having a really bad day. I mean, this should have gone and stayed with the jury. He should have called the counsel in, answered the question, then they should have instructed the jury. And everybody gets to participate. You don't get to cut out the people that are dealing, that say we don't find liability. And I agree that with the approach of the Perkins court, was when you have this sort of fractured result and fractured process, you need to say, well, possibly until the very end they could have changed things if you'd let everybody participate. Well, here everybody did participate, and everybody said Recovery Innovations is liable, and that's one of the key differences between our case and Perkins. Perkins just shocking when you read it. What happened?
Let me explore your point that you just made. You do envision a shorter, different trial the second time around if we have this liability instruction. Is that accurate?
Yes, Your Honor.
How many witnesses did you call in the first trial?
Oh my gosh, there were.
And the next question is going to be, how many do you anticipate calling in the second?
Well, it really depends on what they bring out. I assume it'd be 2 or 3 experts, and then other witnesses about the background for what Medina Jafian was doing.
How can you do comparative fault, though, without going through all of the evidence of fault on the part of recovery? How do you omit that part of the, okay, they did something wrong, but we're assessing how wrong were they? How bad were they? I'm not understanding which witnesses you're going to leave out in the second trial.
Or what areas can you skip?
Well, the focus is going to be on what happened before he gets there, and to some extent, unless they want to try to say that once he got at the facility, they can somehow say that he's to blame for being in a psychotic episode. I don't know how you're going to do that.
Assume you can do that. If you can bring up the fact that he attacked someone and his conduct at the facility, then is the trial any shorter? Is there any way that you're limiting something?
Well, you might. It really depends on how the trial court wants to control things there. But if you're going to accuse a crazy person of being crazy and attacking somebody, what's the world come to? I mean, the reason he's there is that he's having this episode and he can't be controlled at home or anywhere else, so they bring him where he can be controlled and treated. And then you blame him. Well, you're uncontrollable. Well, your job is to control him.
Let me ask, of the 3 sort of inquiries I've highlighted, determination of liability, determination of damages, and allocation of fault. As the record currently stands, the new trial is to allocation of fault only. Your argument is that was not an abuse of discretion, is not prohibited otherwise by law. If the 2 trials, the first trial that got us through those first 2 questions, and then a new trial on the third, allocation of fault, were identical in duration, witnesses, testimony, laboratory circumstances to be sure, would your argument be the same, that it was not an abuse of discretion and was not contrary to law?
If it turned out to be identical in length, the witnesses and everything else?
Or even if the new trial was longer than the first trial, would your argument be different? In other words, is this an efficiency-based ruling, or is it something different from your perspective?
Well, from my perspective, it's both. It should be both more efficient the second time around. It should be much narrower. And I think just on the statute and the procedural rule, this is the right result the trial court reached. I hope
if it's not more efficient for the second trial.
You know, the law of unintended consequences can bite you every time. But the judge
Trying to understand your argument.
I think the trial judge was trying to be fair and efficient and trying to implement the rules as they're written and the statute as it's written. I think it's a good result. Whether it plays out that way at court, I don't know. And of course, then we have that final gorilla in the background of the non-party at fault issue. You know, it's.
Well, I'm trying to understand your suggestion that this would somehow be limited, and that the decedent's conduct wouldn't be relevant. It seems to be suggesting that there's a known standard of anyone who's mentally ill is going to act in this way. It seems like that's a completely the nature of mental illness. I mean, maybe everyone is going to act differently. How can you necessarily say that just because someone has a mental illness, and we don't know what degree or level, that everyone, that the facility has the exact same duty just based on which particular mentally ill patient? It seems odd to me that to suggest that his conduct in the facility is somehow not going to be relevant in assessing comparative fault.
Well, he came under police escort in handcuffs after.
But does everyone who comes in police handcuffs assault someone in the facility?
I assume
the facility,
not, Your Honor.
So why would that not be relevant? So I'm having a hard time understanding how this new trial is going to exclude any piece of evidence that was presented at the first trial. It seems like it's going to be a complete repeat.
Well, it shouldn't be a complete repeat
Other than everybody stipulated that the amount of the overall damages is $2 million.
Well, it won't be a complete repeat. You don't have to prove the facility is liable. That's established. And you don't have to prove damages. That's established.
But to show how liable they are, don't you have to go through all of their conduct, what they did, and how they responded when the decedent behaved in a certain way?
Well, in a sense, we're going to be counterpunching at trial because if I'm correct that Mehdi Najafian is a non-party at fault, I don't see how it could possibly be anything other than a non-party at fault. They have the burden to prove what percentage of fault he has. So they're going to be setting a stage there and trying to prove that he is at fault, and then we'll be counterpunching that and trying to say, no, he's not, or his percentage of fault is minuscule.
So just to piggyback on Judge Thumma's question, if we have an identity of substance, both quantity and quality, trial 1 and trial 2, it's the same trial, how does that impact the rule that issues cannot be inextricably intertwined? Because that's my concern, is how you're having two identical trials. How do you navigate that landmine of not making that inextricably intertwined?
Well, at this stage, the notion of an identical trial is a hypothetical construct. It may be, and it should be different, because at this proceeding, we've got liability established, damages established, and then they have the burden of proving that Mehdi Najafian was comparatively at fault and the percentage of that fault. So it shouldn't be an identical trial. And I think I missed the answering the question, but I'll try one more time if you could narrow it.
You don't have to. That's okay.
All right.
I'm satisfied.
I burned through my time. Thank you very much.
Just a few more things, if it would please the court. The issue of mental illness, we're not just talking about his ability to control his conduct once he was admitted. We're talking about his decision not to take his medication when he was of sound mind and how that contributed to his ability to control his conduct and Recovery Innovations' ability to control his conduct thereafter, which all contributed to an indivisible injury for which the jury has to consider all of it, all the circumstances of the fault when it allocates fault. The second jury cannot apportion fault not knowing how the first jury determined Recovery Innovations to be liable, in which respect that they were liable.
Counsel, you want to preserve the damages finding of the first trial, right?
It's not that I want to. I think that it's right on the border of the trial court's discretion. In Englehart versus Candlelit Health Network, the implication of the opinion is that in rare cases, a wrongful death case where damages are objective, that you can separate damages from the inquiry of liability and comparative fault.
I mean, are you affirmatively arguing that damages should not be revisited here?
I don't think that it needs to. I think that's the one thing that we can say is efficient and was within the trial court's discretion. I mean, that's the standard that we're under.
Is it possible, though, that the jury might want to revisit damages once you break down fault, thinking from the back end, like we do as lawyers, which is we want to make sure this person leaves the courtroom with this amount in their pocket. And so the damage number might change, and under that argument, why not revisit damages as well?
It's a fair point. It can happen. But the question is whether it's within the trial court's discretion, so we've respected that. One quick thing on the non-party at fault issue. Under the UCADA, the fault of the decedent is imputed to the claimant. To then treat that as non-party fault that's going to be offset from the defendant doesn't make any sense. And this issue wasn't raised until the appeal. There was fair notice of it the entire time. I'll leave with this. Liability is not established until we know what relative fault is under the UCADA. And had this first trial been done right, and we could have avoided all the prejudices that we have here, and the trial court was required to resolve any doubt that there might be prejudice. In this trial where the second jury is not going to know how the first jury found them liable, in this trial where they're going to be instructed the defendant is liable right out of the gate, that raises a doubt that there might have been prejudice. Your Honors, for all these reasons, we're requesting that this court modify the trial court's ruling to include a retrial on liability. Thank you.
Counsel, thank you very much for your enlightening argument, and we will conference and issue a decision in due course, and with that, we are adjourned.